Hi, this is Professor David Opterbeck. Welcome to the second lecture in our module on computer crimes. Tonight we'll primarily talk about the Computer Fraud and Abuse Act. Now, there are a number of federal statutes as well as state statutes that deal with what we were calling computer crime in this module. Here's a chart of some of the relevant federal statutes. You'll see at the top the Computer Fraud and Abuse Act, which we'll talk about in detail in a moment. The Wiretap and Stored Communications Act deal with access to information in transit or in storage. We'll talk more about those in the next module on national security if you take that module, and surveillance. The Access Device Fraud statute deals with certain kinds of devices that allow for access to computer networks. The CAN-SPAM Act deals with spam. The wire fraud statute is a traditional wire fraud statute originally sort of in the telephone age. That also includes wire fraud conducted over the internet, and communications interference involves interfering with communications networks. All of those statutes are important. Our primary focus in this section will be on the Computer Fraud and Abuse Act. We will also be looking in a couple of weeks at statutes that deal with personal safety online. Many of those statutes, both federal and state statutes, deal with vulnerable people, especially children. And pretty much everyone agrees that it's important to protect children online, but it's difficult to figure out exactly how to do that consistent with our First Amendment values. And you'll see that there's quite a lot of jurisprudence we'll look at dealing with the First Amendment question and child pornography statutes. For today, however, we're primarily going to talk about the Computer Fraud and Abuse Act. Now, as you look at the statute, you'll see that there are a number of specific offenses listed under the statute, and if you look at it carefully, you'll notice that most of those offenses deal with the question of access. Either accessing a computer without authorization or accessing a computer system in excess of authorization. You'll see the term in the statute, protected computer. These days, a protected computer basically means any computer that's accessible on the internet, which pretty much means any of this activity is covered. Why are most of the activities under this statute related to access? And part of this has to do with the roots of the statute back in the 1980s, when computer networks were mostly hardwired networks. You had a mainframe computer, you had dumb terminals at your desktop, everything was hardwired, there was no public internet, and so most of the things you thought of as crime involved access. You'll see, even as you look at this, that some of these definitions have been substantially broadened to try and deal with really kind of the malware era. There have also been proposals to change the statute even further. I doubt whether any of those proposals are going to go anywhere. Some of those involve increasing actually some of the penalties. Some of those actually involve decreasing the discretion of prosecutors. One reason that there have been some proposals to decrease the discretion of prosecutors is because of the Aaron Swartz case. I asked you to look at the Aaron Swartz case so you could see the kind of impact this sort of statute can have on people. As the story in your materials suggests, Aaron Swartz was a sort of internet rock star. He invented the RSS protocol when he was very young, a protocol that was widely used in syndication of blogs and things like that. He was very much involved in sort of internet activism causes. He apparently, as part of his sort of internet activism or hacktivism, hacked into the MIT computer system. It wasn't a very sophisticated hack. He sort of found a way to plug into the network, and he downloaded a large number of articles from the university's JSTOR account. JSTOR, if you're familiar with it, is a library subscription-based service to research journals, and he made those articles widely available to the public. Swartz was caught, he was arrested, and he was charged by the U.S. Attorney with various crimes, including a variety of crimes under the Computer Fraud and Abuse Act. And if you kind of look at the potential penalties under the indictment that he was charged with, he could have spent decades in prison. Now, it's very unlikely that he actually would have been tried and convicted of all those counts and sentenced to decades in prison. The most likely outcome would have been some kind of plea bargain, perhaps with no jail time or a very small amount of jail time, though with probably a felony conviction. So either way, it was a serious thing, but ultimately nothing materialized. A plea bargain didn't materialize. A trial didn't materialize because Aaron Swartz unfortunately committed suicide. Now, the materials you have demonstrate a little bit that Aaron Swartz was a very troubled person. Obviously, no one can say for sure why he committed suicide, but it does appear that at least the stress of this prosecution played some part in it, and that did raise many issues about the scope and the use of these statutes. So you ought to sort of keep that in mind as we go through the nature of this statute. So let's look in depth at some of the actual provisions of the statute, and I've just tried to kind of break some of these down a little more conveniently than they are worded in the statute, but you should read the statute itself. Section A1 relates to national security information, and if you read the statute, you'll see the kinds of information that it's referring to. Notice that there is a scienter requirement, knowing access to a computer without or in excess of authorization, obtaining national security information, reason to believe the information could injure the U.S. or benefit a foreign nation, willful communication, delivery, transmission, or attempts, or willful retention of the information. And this one is probably pretty intuitive. Section 2 is one that might be a little bit surprising to you. Compromising confidentiality. So notice the elements: intentional access, with or without or in excess of authorization, so there's your scienter element, and you're obtaining information from financial records of a financial institution or the U.S. government, and maybe those are sort of intuitive, or information from any protected computer. So what does this really mean? It really means that any intentional access with or in excess of authorization of any computer that is connected to the connected to the internet is a violation of federal law, because whenever you're accessing, you're obtaining some kind of information. So really, in a sense, now it's broader than this because you can see all the elements, but in a sense, just access itself, because access is always going to entail obtaining some kind of information. If you don't have authorization, or if you're acting in excess of authorization, is a violation of federal law. Trespassing in a government computer, this is another one that's probably a bit more intuitive. Intentional access without authorization. A non-public computer that is a U.S. government computer as the statute defines that. Accessing to defraud and obtain value. So this is, again, knowing access without or in excess of authorization with an intent to defraud, and the access furthers the fraud, and you're obtaining something of value, including the use of the protected computer. And notice that there's this $5,000 value threshold. Now you'll see this threshold at a number of places in the statute. You should realize that this is actually quite a low threshold. This can include remediation costs, investigation costs, a number of things of that nature. So it's very easy to meet this threshold. So in section A5, A through C, we have damaging a computer, and you'll see that there's 3 different aspects to this. Under Part A is really the malware section of the statute, in a sense. So knowingly causing transmission of a program, information, code, command. The result of such conduct intentionally causes damage without authorization to a protected computer. Notice that this is without authorization. It's not intended to get at some kind of authorized use of a program that sort of, makes some kind of mistake or causes some kind of harm, unless it's something that we would consider something like malware. Part B, intentional access, protected computer without authorization. and recklessly cause damage. And then Part C, intentional access without authorization, cause damage. And you'll see when we look at the penalties, if you recklessly cause damage, the penalties are potentially higher than simply causing damage, which doesn't necessarily have to be reckless. So trafficking in passwords, this is trafficking in a computer password or similar information, again, knowingly or with the intent to defraud, and the trafficking affects interstate commerce or a computer used by or for the U.S. Recall the days of constitutional law. It's not hard at all to affect interstate commerce. Any computer that's connected to the internet is affecting interstate commerce. Threatening to damage a computer. This is really the extortion section of the statute. So with the intent to extort money or any other thing of value, transmitting a communication which contains either a threat to damage a computer, threat to obtain information, or a demand or request for money where there's a facilitation of the extortion. Now this slide shows the penalties for violations of the statute. And you will see in parentheses the maximum sentence for a second or subsequent offense, and otherwise the maximum sentence for a first offense. All of these offenses also carry the possibility of fines. So a few things you should notice about this. Notice the length of the possible prison terms can be pretty significant. Notice that even the compromising confidentiality, the simple access and obtaining information, can be up to a year in prison. So that's a pretty significant penalty for simply accessing. If you kind of work your way down, look at the knowing transmission and intentional damage provision. This is really dealing with the kinds of access or hacking that might have kinetic effects. In other words, physical effects in the real world, destroying equipment, injuring people, or even killing people. And it is quite possible to hack into systems and cause them to overload and even explode and things like that. So if you notice in this section, the penalties go all the way up to life in prison if you attempt to cause or knowingly or recklessly cause death through knowing transmission and intentional damage. So obviously very significant kind of penalty. And if you go further down, you can see the different. And if you go further down, you can see the different penalties for different aspects of the statute. Certainly the penalty provisions of this statute are among the most controversial. In the Aaron Swartz case, he was charged under a number of these sections, and as I said, theoretically could have been facing decades in jail. The proponents of Aaron's law want to see prosecutorial discretion and penalties for certain kinds of offenses lessened. There are proposals, including a proposal by the Obama administration of a couple of years ago, to actually increase some of the penalties. Again, I don't think any of those proposals are going to go anywhere, but this is a significant place at which there is debate over what exactly this statute should or shouldn't do. I wanted to just note for you that there is a New Jersey computer crime statute that in many ways is similar to the Computer Fraud and Abuse Act. In fact, most states have similar statutes to the Computer Fraud and Abuse Act. In fact, state law actually in California preceded federal law on these issues back in the 1980s. From my conversations with people in the computer crimes offices of New Jersey County prosecutors and of people I know in the New Jersey State Police, which investigates computer crimes, there's not a lot of activity in the New Jersey state courts under this part of the New Jersey computer crime statute. There's certainly a lot of this crime going on. In fact, there's a huge amount of this crime going on in areas like Atlantic City, where there's a lot of money flowing in and out, and computer networks are heavily involved. But there's not a lot of prosecution by the state authorities because they simply don't have the resources. Most of the state resources in this area are unfortunately dedicated to trying to prosecute child pornography, which is an enormous problem. And we will talk more about that when we do our unit in this module on child pornography. Okay, let's take a look at some case law, and I've asked you to look this week at a number of cases that deal with territoriality and other kind of related issues under the statute. Next week we will look at cases that deal with the question of when access is in excess of authorization. You'll see that there's some interesting debates in the case law about that question. So the first question is this Ivanov case. I want you to see these cases for their legal holdings, but also factually it's kind of interesting to see the different kinds of criminal activity that's involved and the way in which the federal government tries to prosecute some of this activity. So in Ivanov we have a hacker located in Russia. He's gaining root access to an ISP's computers. Root access is really the sort of lowest, most basic level of the operating system stack. It allows for essentially total control over the system that you have access to, and it also can be very hard to sniff out even with antivirus software. So Ivanov then seeks to extort this ISP, sends them a threatening email. He sends the email through an ISP located in Washington State in the U.S. So the issue is whether the CFAA can be applied extraterritorially. The court says it's common in criminal law that a person can be charged in the place where the evil results, even if the person, him or herself, is beyond the jurisdiction when the chain of events that leads to the evil is started. Here, all of the intended and detrimental effects, the malware that goes into the computer, the extortion occur within the United States. The court talks about this issue of intangibles, of data that's being sort of held captive for extortion, and says that when we're dealing with intangibles, it's the place of the control over those intangibles that matters. And here the court says Ivanov possessed the data on the ISP's computers in Connecticut when he obtained root access. And he had credit card data, that consumer credit card data from those computers that he then transferred to Russia. And the court also notes that the statute was specifically amended in 1996 to include that a protected computer is not only in interstate commerce, but also in foreign commerce. Now, it's interesting to note all this as a holding under the CFAA. The practical consequences of this, may not be so great. It really depends on whether there's an extradition treaty, whether the country with which there's an extradition treaty is even willing to extradite. As a practical matter, an individual hacker in Russia, unless somehow they've traveled to the U.S. and been arrested, is going to be very hard to extradite. And the same would be true for many other locations that are sort of prominent hacking locations. Certain parts of Africa, China, North Korea, and so on. It's interesting jurisprudentially, I think, when you think about our first module on internet governance. Think about the Yahoo case from the very beginning of that first module and all these questions that we raised about who has jurisdiction on the internet. Well, here is a U.S. federal criminal statute that suggests that U.S. authorities have jurisdiction on the internet whenever there is conduct that reaches into the United States and affects intangibles that are under someone's control in the United States. So I also asked you to look at the Willis case, and the Willis case is an insider case that is also tied to more traditional kinds of crime. So in Willis, the defendant works for a debt collection agency that uses a commercial database to obtain information on individuals in order to collect their debts. The defendant's job involves managing passwords that give access to this database. and the defendant gives a username and password to his drug dealer in exchange for drugs, and shows this a person who he meets through the drug dealer how to use the database. Defendant claims he's only helping this person obtain information on people who owes this person money, as though that would really be that much better. I'm not sure that it would. But the specific legal issue is, did he have an intent to defraud under the fraud portion of the CFAA? Now, one thing I do want you to notice factually about this is the fact that there is this internet-based crime, this computer-based crime, that is connected with real-world crime. And you ought to have a sense, from our first lecture in this module and as we go through this, that very often is true. It's very often true on this very mundane level of drug dealing, prostitution, child pornography, other kinds of contraband. But it's also true in terms of financing. So, as we mentioned in the first lecture, there is a lot of organized crime activity in cyberspace. There is also a lot of organized crime activity that is involved in finance channels that help finance terrorism. Many of these things are connected. So, the court says that looking very carefully at the statute, one portion of the statute requires a specific intent to defraud. Another portion of the statute does not require a specific intent to defraud. That portion of the statute simply is access-based. And so at the very least, there's going to be a violation of that portion of the statute. And further, the penalty provisions of the statute do not add any separate intent or knowledge requirement. So, the legal holding simply kind of distinguishes when you need intent to defraud and when you simply need intent to access. But I think it's an interesting case to look at also factually. So I also asked you to look at the Butera case. And as you'll see, the Butera case is a civil case. There is a provision in the CFAA for civil causes of action. It isn't really used that often, this civil cause of action provision in the CFAA. Most of the time when it is used, it's in the context of some kind of dispute with a former employee who has left the company to start a competing business, or is trying to find a different job, work for a competitor, and it's really a restrictive covenant or fiduciary duty or trade secret case. Those kind of cases can be really hard to prove. And so sometimes a CFAA claim will be tacked on. And we'll see next week how courts have tried to deal with that. This case is interesting because it deals with the issue of respondeat superior, and in particular whether a corporate entity that controls the computers at an IP address from which an attack originates is responsible for that attack. So here we have a plaintiff, which is a law firm. In this case, it seems to be a pretty small firm. The attack is a denial of service attack, which is an attempt to overwhelm the firm's computer systems with traffic. Now, you should note, it's not really from this case, but you should note that law firms are a huge target. If you think about a law firm, they have an enormous amount of personal information on their clients, medical information, personal history, marital information, financial information on individuals and corporations. And law firms, of course, have fiduciary duties and ethical duties to their clients to secure the confidentiality of that information. So there's a significant amount of activity trying to hack into law firms and a significant amount of extortion activity involving law firms. And I have heard of cases in which law firms, in fact, have paid the ransom because it would be incredibly embarrassing, especially for a large corporate law firm, to have to admit that its systems were violated. It raises all kinds of really difficult ethical and other issues. Law firms are very much attuned to this, and it's a very important issue for firms. Here, a somewhat earlier time, a different kind of firm. The plaintiff law firm very cleverly sues John Doe's. A John Doe proceeding is one against when you can't really identify who the actual perpetrator is. You're preserving statute of limitations. You have access to some discovery to try and figure out who that person is. They also sue IBM. And the issue is IBM liable for this conduct? So here, the court says that the various provisions of the CFAA under which this claim is brought are intent-based. And this court says the basis of the intent is not simply a minimal standard. There has to be some actual intent, even if it's only intent to access. If IBM itself did not authorize these attacks, then there's no grounds for finding that IBM committed any intentional acts. It would only be an employee of IBM. And really under the kind of traditional theories of vicarious liability, you would say either IBM, if IBM knew of this conduct or and allowed it or specifically authorized it, then you might find the requisite intent. But since they didn't, you can't find it here. So I do want you to note the legal holding about intent, but I also want you to note the fact that this is a case that involves law firms and kind of some of the threats that are facing law firms. So that's it this week for our initial overview of the CFAA. I will see you in class on Thursday, and next week we will dive even deeper into the CFAA's issues regarding what it means to access a protected computer without authorization.